We have one case for video oral argument this morning, which is State of Ohio versus Michael Calhoun. Mr. Bedvick, the state has waived oral argument. You will have 15 minutes to present your argument. When you're doing so, please don't use the names of any victims or children, as we are live streaming this and it will later also be available on YouTube. The court's read the briefs. We're ready to proceed when you are.
Thank you very much, Your Honors, and may it please the court, I am Alan Medvick. I'm here on behalf of the appellant, Michael Calhoun, who's appealing his convictions of several counts of felonious assault with associated firearm specifications and a sentence of 20 years imprisonment. While there's arguments regarding an assignment of error regarding insufficiency of evidence and manifest weight, all of this principally comes down to the improper admission of out-of-court statements by one of the witnesses, a Mr. Vinson, who at the time of trial refused to testify, and after previously determining that the police statement that he had given was testimonial hearsay, and having sustained the objection of Mr. Calhoun's counsel, that was permitted to come in as I'm not quite sure. I think that the reasoning of the court and the prosecutor was that it was somehow impeachment evidence or inconsistent statement evidence. I would contend that first, that it did not fit it within any articulated hearsay exception under the Ohio Rules of Evidence, and additionally, it was clearly testimonial out-of-court statements provided for, which by Mr. Vinson, which have to be excluded under Crawford versus Washington. That's a constitutional violation of Mr. Calhoun's right to confrontation. And principally, I think that those errors are clear. I want to start by addressing the question of harmless error that was raised by the prosecution and by the appellee in its brief. This was not harmless error. To have harmless error, you have to show that the error was harmless beyond a reasonable doubt, that there is no reasonable expectation, no reasonable calculation that the witness, that the inadmissible evidence, the erroneous evidence was the basis for, or a basis for the conviction. And in this case, that statement and the statement that came in was that Mr. Calhoun shot that girl for no reason, I believe is the statement that was admitted, is damning in and of its own right. And to exclude that, you're left with the witness statements of the victim, Ms. Stutz and Ms. Casey, none of whom.
Before you get, counsel, before you get to that, remind me, was there a limiting instruction given by the court when that evidence was admitted? There was
a limiting instruction, but I would contend A, that the limiting instruction itself was erroneous, based in a misconception of what was permissible, and B, that the statement is so clear and so and the limiting instruction was that the statement was that the document was permitted to go back, the written statement, and the statements of Mr. Vinson were admitted into the record as impeachment evidence for prior statements that he had made. The only prior statement that he had made that would have been refuted by that note was that he had actually written the note. He said, I don't remember writing the note. I don't remember. He never made a denial that Mr. Calhoun was the shooter. He never made a statement. He never made any statement that anything contained in that document would have refuted. The only thing that the detective could have and should have testified to be an impeachment statement was, did Mr. Vinson write this statement? Whatever else was written on that paper was inadmissible hearsay and not related to any statement that Mr. Vinson made in court at any point. And so the limiting instruction itself does little to limit to correct the error. And in fact,
was it as specific as something to the effect that the statement could not be considered for the truth of the matter asserted?
And that may have been stated, but again, this is a a bell that should not have been struck, and I don't believe was properly unstruck, if that can ever happen, by the limiting statement. There was a limiting instruction, and as I contend in my brief, I think the limiting instruction is erroneous and based on faulty logic and faulty application of the law. And again, I think that those statements were presented and in direct contrast and violation of the Confrontation Clause and the application of Crawford versus Washington. And again, those statements are far from harmless. To get to the victim's identification, in two different in photo arrays, she identified the victim, or Mr. Calhoun, at a 60% reliability rate, which is obviously not something high enough to constitute reasonable doubt. And in fact, it identified another person in that photo array at the same possibility of reliability. So that she had a reliable testimony, and this was all in the record and presented to the jury. Her basis for claiming that Mr. Calhoun was the shooter was after she had seen him already detained, already in custody at the juvenile court hearings prior to the bindover in this matter. And at that point, as you know, that's a highly suggestive identification, and I would say incredibly unreliable. The other two witnesses, Ms. Stutz, had no identification information at all. She had testified that she was purely focused on the gun, and Ms. Casey had given contrary and contradictory statements prior to being in the witness stand and testified to being inebriated. So to say that you can reach beyond a reasonable doubt that Mr. Vinson's out-of-court statement did not contribute to this conviction is, I think, an impossibility. And I think that that's where we are here. And as I stated in brief, the proposed reasons for allowing this evidence in were as prior inconsistent statement, which seems to be the prosecutor's argument that it's non-hearsay, but that requires that the statement had been given under oath, and that was not done in this case. And that the declarant testify at trial. And I think that the issue here is one of unavailability, that Mr. Vinson abjectly refused to testify, even over threats of contempt. And I would contend that the manner in which the court conducted that eyewitness testimony, or that testimony of Mr. Vinson, was in and of itself prejudicial. That he was allowed to continue, the prosecutor was allowed to continue to ask questions over the objections of Mr. Lowry, Michael Calhoun.
What happened, counsel, after the state concluded its inquiry of Mr. Vincent? Was there any opportunity for cross-examination, even though he continued to refuse? Was there?
And I will tell you that in the record, the trial judge does ask Mr. Calhoun's counsel if he has any questions, but and there is no, and he states that he has no questions. But at that point, with Mr. Vincent's refusal to testify on direct, I'm not sure what the benefit of that would have been in any way. And so I would contend that there was no real opportunity, there was no real testimony put forward, and there was certainly no cross-examination made regarding. And after those statements came in, there was no opportunity by that I could tell that Mr. Vincent could be recalled, or was given an opportunity to be recalled to address those issues, which I think are paramount in admitting those statements, that the witness has to have an opportunity to testify to them. He abjectly refused to do so. And I would say that the trial court, in, I don't know how to phrase it, threatening contempt, but never actually removing the witness from the stand to try to address that contempt, to halt these proceedings, allowed a prejudicial, unanswered inquiry to continue by the prosecution. And this was exacerbated and doubled down on by the prosecution when Detective Gary was allowed to read directly from the written statement. And then the written statement was admitted as evidence. And as I said, there was no fact at issue or test statement at issue that was refuted outside the fact, and which is an irrelevant fact, that Mr. Vincent had written this statement himself. And and as a matter of relevance, the fact that Mr. Vincent gave a written statement does not make in and of itself any relevant issue more or less likely to occur. So this statement, whatever would be rebutted, was irrelevant evidence, and anything beyond that was inadmissible hearsay. And so with that, this is a case where the unconstitutional statements of Mr. Vincent clearly prejudiced my client, clearly resulted in a conviction that is improper. And I think that the trial court erred in not granting Mr. Lowry's motion for mistrial at several points in this proceeding, and certainly not the and certainly the Rule 29. Well, I would contend that the mistrial is the more appropriate remedy, but without the evidence of Mr. Vincent, there's a manifest weight and an insufficiency of evidence issue as well. The other eyewitnesses, and while I understand that the jury is in the best position to interpret and judge the reliability of the eyewitnesses, in this case, this court cannot say in reviewing this case that beyond a reasonable doubt, the out-of-court statements of Mr. Vincent did not influence and were not critical to the conviction of Mr. Calhoun. As I've indicated in the brief and here, the statements of the other witnesses are inconsistent and insufficient in and of themselves to overwhelmingly lead to a conviction. And I think that's the standard that on appeal that we have to meet. And I don't think that the state has done that. And so I would ask that this court reverse the trial court, find that there was a mistrial in this case, and remand for further proceedings.
Was the statement obtained at the police station?
It was, I believe it was yes, and it was obtained from Detective Gary himself. It was unquestionably a testimonial statement, that there was a statement given in response to police inquiry. And so it unquestionably falls within the testimonial statements articulated by Crawford versus Washington.
How does a statement stand up to he did say he never met with the detective, I believe. He claimed he testified he wasn't present at the scene. He didn't fire any shots. He didn't recognize the note, and he didn't remember it. So I guess this really comes down to whether or not any of those statements are prior and consistent statements that would provide the exception. And I know you've talked about this, but just sort of summarize that for me.
Well, and one thing I would contend is first of all, I don't know that those things necessarily rise to the level of inconsistent statements. Secondly, even if there is an evidentiary rule allowing this testimony to come in, there is unquestionably an issue with the confrontation right regarding Crawford that does not, and Crawford is very specific that it is outside of evidentiary rules and indicia of reliability. This is an abject, unquestionable, inviolate right to confrontation, and that Mr. Calhoun did not get in this case. And
thank you.
So if there are no other questions, I would cede the balance of my time.
Seeing none, thank you, Mr. Medvick, for your presentation today. The
Thank
court
you.
will take a matter under advisement. We will issue a written decision, which will be mailed to the parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next video oral argument is Thursday, May 6th.
Thank you very much. You all have a nice day.
Thank you.
Good.